Welcome back, everyone. This chapter is all about how work is changing dramatically. It explores fundamental transformations in modern work arrangements and their legal and ethical implications. The traditional employer-employee relationship that dominated the 20th century is given way to more flexible, technology-enabled arrangements that challenge existing legal frameworks. Flexible, tech-enabled work like freelancing, gig work, and platform-based tasks are redefining what it means to have a job. We'll look at how these new models challenge laws and ethical expectations. Have you ever been paid on a per-job basis? For example, babysitting or done yard work for a neighbor in exchange for payment? Or have you or someone you know worked for Uber, Instacart, or freelanced online? These common experiences are a good starting point for discussing the gig economy. The gig economy represents a particularly significant shift, with platforms like Uber and TaskRabbit creating new categories of work that don't fit neatly into our existing legal categories. Here's an example. A student earns money driving for DoorDash on weekends. They can pick their hours, but they get no health insurance or job security. So, is this empowerment or exploitation? Consider using this hypothetical. Hannah and Roger Johnson hired a babysitter named Anna through a website called babysittermatch.com. The site offers the potential sitters to post their bios, references, and photos on the site, but only after the site confirms their qualifications and calls their references. Parents then can search the site for sitters in their area for a small fee. Unfortunately, while Anna was babysitting the Johnsons' 3-year-old daughter, Cecilia, an accident occurred. Anna left a pair of sharp scissors on the floor, and while Anna was in another room, Cecilia picked up the scissors and cut herself in the leg with them. The laceration was deep, and Cecilia had to be rushed to the emergency room. Cecilia recovered from the injury, but not before enduring $150,000 in medical care, including surgery to repair a tendon. Should the company that runs babysittermatch.com face any liability for Anna's negligence? Think about this as we go through this chapter, and I'll ask it again to see if your thoughts have changed on this situation. Throughout this presentation, we'll explore how courts, legislatures, and new businesses are responding to these challenges. We'll examine the gig economy, labor standards, worker classification, and emerging business models that are reshaping our understanding of work in the modern. The gig economy represents a fundamental shift from traditional employment to task-based on-demand work. Many trace the rise of the modern gig economy to the 2008-2009 financial crisis, when high unemployment drove workers to seek alternate income sources. According to a 2023 Pew Research study, approximately 27% of American workers now participate in the gig economy in some capacity. Technology platforms emerged to facilitate these connections, creating entirely new business models. Rather than viewing this trend as entirely new, however, we can recognize that gig work has historical precedents. Temporary work, day labor, and freelancing have always existed. What's new is the scale, technological mediation, and increasing normalization of these arrangements across industries that were previously dominated by traditional employment. These platforms function as intermediaries connecting service providers with customers. They're typically asset light. They own no vehicles, inventory, or real estate. They use rating systems to maintain quality control, and they all have faced regulatory challenges in nearly every market they've entered. So let's talk about some of these platforms. You may be familiar with some or all of them. Uber, founded in 2009, now operates in 72 countries with over 5 million drivers. In some countries like Germany and the Netherlands, Uber was officially banned. When drivers were caught violating the Uber ban, the company would pay their fines. Who are the stakeholders in this situation? Is Uber's practice of paying its drivers fines ethical? In 2016, Uber was assessed an $11.4 million fine for operating a transportation business in Pennsylvania without a license, and continued its operations. Who benefits and who is hurt by this attitude towards rules and regulations? The stakeholders in these situations include Uber, potential Uber drivers, taxi drivers, and drivers for other Uber competitors. Consumers who use Uber and its competitors, and the government. In these cases, Germany, Netherlands, and Pennsylvania. Now, from Uber's perspective and a free market ethical approach, this is ethical as long as Uber is making more from having drivers operate in these places than it has to pay fines. Uber takes approximately 25% of each fare, and they use an algorithmic pricing, what we call surge pricing, during high demand periods. In 2023, Uber reported its first full year of profitability since going public. Instacart. Founded in 2012, this grocery delivery service uses both in-store shoppers, classified as part-time employees, and delivery drivers, classified as independent contractors. Their model shows how companies can create hybrid structures. Upwork is very popular, especially among small businesses. This professional services platform hosts over 20 million freelancers, ranging from web developers to graphic designers to accountants to social media managers. It charges a sliding fee based on lifetime earnings with each client, 20% for the first $500, decreasing to 5% for earnings over $10,000. In a recent update, Upwork announced a new tiered fee structure to better reward loyal freelancers. TaskRabbit, now owned by IKEA, specializes in home services like furniture assembly, cleaning, and moving help. Taskers, as they're called, set their own rates, but TaskRabbit adds 15% service fee on top for customers and takes a percentage from the workers. And Airbnb, and the hospitality market we're all familiar with, it was founded in 2008, now has over 7 million listings worldwide. Unlike some other platforms, many hosts are individuals just monetizing an asset, their home, their beach house, etc., rather than their labor. Though professional property managers are increasingly using the platform as well. So, in thinking about this, is owning your work schedule worth giving up benefits and protections? Classification matters tremendously to both workers and businesses. For businesses, independent contractors can reduce costs by 20 to 30% compared to employees. This includes savings on benefits, unemployment insurance contributions, workers' comp premiums, employer-side payroll taxes, and overhead costs associated with HR compliance. For large companies with thousands of workers, misclassification can represent billions in potential liability. For workers, employment status provides crucial protections and benefits that create a financial safety net. The question isn't just theoretical. It determines whether someone who gets injured on the job gets medical care covered, whether they can collect unemployment if the company downsizes, and whether they're protected by anti-discrimination laws. Independent contractors gain flexibility and potential tax deductions, but they lose these protections. Real-world impact. In 2023, California's Proposition 22, which allows companies to classify drivers as contractors, was upheld in court despite worker protests. This affected over 1 million gig workers. Now, courts apply different tests depending on the jurisdiction and the specific law at issue. The right to control is often the most significant factor across tests. These tests, however, reflect an ongoing tension between adapting to new work models while preventing companies from evading worker protections through strategic classification decisions. An example would be Amazon Flex drivers have freedom over their hours, but they follow strict route and performance tracking. So let's talk about the four main tests used for classification. The control test focuses on who controls the work process, sets the hours, location, methods. This traditional common law approach examines who provides tools and equipment, who sets the schedule, and who determines how the work is performed. Another test used is an economic reality test. This examines the worker's economic dependence on the employer. Courts consider in this case whether the worker has multiple clients, has made investments in their business, their opportunity for profit and loss, and the permanence of the relationship. Now, the Department of Labor guidance was established in 2021. This created a 6-factor test considering workers' control, their opportunity for profit loss, skill required, permanence of relationship, whether the work is integral to the business, and the nature of the working relationship. And finally, we have the proposed flexibility test. This suggests that worker flexibility in determining when and how much to work should be a primary consideration, better reflecting modern work arrangements. Here's an example of that. Fernandez delivered pharmacies to Kenray's customers. He owned and operated his own vehicle, was subject to credit and criminal investigations before being hired. He was required to report at a specific time and follow specific routes. He was disciplined if he arrived later or failed to make deliveries as directed. Under the current standard and the proposed flexibility test, it appears that Fernandez was an employee, though more information would need to be known about whether he relied on this job as his sole source of income and the total number of hours he worked. He did not have much flexibility in his hours, and the company controlled much of his work. In this case, the court found that his argument that he was an employee was at least plausible. Here's another case I want to look into a little more. Cotter versus Lyft. This case exemplifies the challenges courts face when applying traditional worker classification tests to platform-based businesses. This case demonstrates how existing legal frameworks really struggle to categorize platform work. So what difference does categorizing the drivers make? Well, I'm so glad you asked. Employees are entitled to certain benefits and protections that independent contractors are not. They include minimum wage, reimbursement for work-related expenses, and unemployment benefits. Classifying Lyft drivers as employees would grant them access to these benefits and protections at a great expense to Lyft. Now, Patrick Cotter and the other Lyft drivers filed a class action lawsuit claiming they were employees entitled to minimum wage, expense reimbursement, and other protections under California law. Lyft controlled driver standards, Lyft set the fares, Lyft monitored performance, and Lyft could terminate drivers. The scheduling flexibility that allowed drivers to work whenever they wanted or not work at all stood in stark contrast to traditional employment relationships. If Lyft has this right to control, the drivers are employees under California law. Here, the fact that Lyft drivers can work whenever they want, for however long they want, suggests that they're independent contractors. However, beyond that, Lyft exercises a lot of control over how drivers act when they're driving for Lyft, such as how they greet the passengers, and set standards for their vehicles and insurance. They're also not performing a task that requires specialized skill, which is typical of independent contractors. Now, in this case, the ruling was not clear enough for a summary judgment. Judge Vince Chabria famously wrote that the case was like being asked to determine whether Lyft drivers were square or round pegs when the hole is actually somewhere in between. In 2023, Lyft agreed to pay $27 million to settle misclassification claims in California while maintaining drivers as independent contractors. The ultimate settlement allowed Lyft to maintain its business model while providing some compensation to drivers, but it did not resolve the underlying classification question. Now, the Fair Labor Standards Act of 1938 established minimum wage and overtime protections, but it doesn't easily apply to some modern work arrangements. Some jurisdictions are creating new frameworks specifically for gig workers. With California's AB 5 law and city-specific minimum pay standards attempting to address these challenges. Here's some key concerns. Minimum wage. In 2023, New York City's Taxi and Limousine Commission mandated that ride-hail companies like Uber and Lyft must pay their drivers at least $19.96 per hour after expenses. But calculating this rate became contentious. Should waiting time between rides count? How should car expenses be calculated? Are drivers, quote, working when they have multiple apps open simultaneously? We can think about this in terms of fair pay. Some gig workers earn below minimum wage when factoring in the cost. Protections is another area to address. Anti-discrimination laws often don't apply to contractors, creating protection gaps. Think of it like this: injury protections, no formal workers' comp if hurt on the job. Another area of concern is overtime. Instacart faced lawsuits where shoppers argued waiting time should count towards overtime calculations. Think of this in terms of work hour. They're unclear when work actually begins, and waiting time is often unpaid. And the last area of concern is workers' comp. Delivery drivers injured while working typically aren't covered since they're classified as independent contractors. Think of this like a safety net. COVID-19 really revealed how vulnerable gig workers are. Many lack access to sick leave or unemployment. The legal framework for unpaid internships has evolved significantly over the past decade. Prior to 2015, the Department of Labor used a strict six-factor test derived from a 1947 Supreme Court case, Walling versus Portland Terminal Company. Under this test, all 6 factors had to be met for an internship to be legally unpaid. In Glatt versus Fox Searchlight Pictures from 2015, unpaid intern workers who worked on the Black Swan film production sued, claiming they performed work that should have been compensated. The Second Circuit rejected the DOL's rigid test and established a more flexible primary beneficiary test that we'll discuss in the next slide. Now, in 2023, fashion brand Louis Vuitton faced criticism for advertising a 6-month unpaid internship for a graduate position requiring advanced skills, highlighting ongoing debates about exploitation in prestigious industries. More employers now offer paid internships due to the pressure from advocacy groups and talent demands. Another test that can be used is the primary beneficiary test. This 7-part test now is the DOL standard. It ensures internships that are aligned with education, time-bound, clearly non-compensated, and not replacing regular staff. Courts balance these factors rather than requiring all of them to be met, allowing for a more nuanced analysis of the modern internship arrangement. Each factor deserves careful consideration. Now, this test focuses on expectations at the outset. If there was any promise or implication of compensation, this weighs towards employment status. Documentation of these unpaid nature of positions becomes crucial. It also examines whether the internship provides educational value similar to classroom learning. Structured mentoring training sessions, and skill development weigh towards a legitimate internship, while routine tasks with minimal educational component suggest employment. In the Glatt versus Fox Searchlight Pictures case, the appellate court found the DOL test to be too rigid. In its stead, the court's primary beneficiary test is more flexible and allowed the court to weigh and balance a non-exhaustive list of factors, while the DOT request required that all 6 of its factors apply. While some of the considerations overlap, the court's test is focused more on finding that the internship is a learning opportunity for which no compensation is expected. So let's look at a case and walk through the primary benefit test. While Alistair Mark was pursuing a degree in journalism at the New School, he worked approximately 20 hours a week from May through August as an unpaid intern for Kotaku, Gawker's video game blog. He assisted the blog's editors and writers, took photos and videos, edited images, researched, wrote, and edited posts and articles. All told, Kotaku published 34 articles written by Mark. He received academic credit for the internship. He received no classroom training, only the same on-the-job training under a mentor that Gawker gave its paid employees, and his work was similar to that performed by the employees who supervised him. So let's apply the test and see how that looks. The first measure in the test: the extent to which the intern and the employer clearly understand that there is no expectation of compensation. Any promise of compensation, expressed or implied, suggests that the intern is an employee. Here, in this case, it appears Mark did not expect compensation, which suggests that it was an unpaid internship. The second measure in this test is the extent to which the internship provides training that would be similar to that which would be given in an educational environment, including the clinical and other hands-on training provided by educational institutions. Now, in this case, some of the training would be similar to that which would be received in an educational institute. However, because the training mirrored that of paid employees, it seems to suggest that Mark was an employee. The third measure is the extent to which the internship is tied to the intern's formal educational program by integrated coursework or the receipt of academic credit. Now, Mark received no classroom training, suggesting he was an employee, but he did receive academic credit, suggesting he could be unpaid. The fourth measure is the extent to which the internship accommodates the intern's academic commitments by corresponding to the academic calendar. The internship ran the course of the summer, which is typical for college students, and accommodates their calendars and suggesting that he could be unpaid. The fifth measure, the extent to which the internship's duration is limited to the period in which the internship provides the intern with beneficial learning. Now, this is unclear from the facts provided, as it really depends on how long his training lasted and the extent to which his mentor provided educational guidance when Mark performed his work. The sixth measurement in this test is the extent to which the intern's work complements rather than displaces the work of paid employees while providing significant educational benefits to the intern. Mark seemed to do the work that displaced the work of paid employees. And lastly, the seventh measurement in this test, the extent to which the intern and the employer understand that the internship is conducted without entitlement to a paid job at the conclusion of the internship. Now, in our scenario, this factor is not addressed. So you can see from that test, in that scenario that we just went through, how it can be applied to a real situation. Now, millennials are redefining entrepreneurship. Millennials born 1981 to 1996 and Gen Z born 1997 to 2012, often approach their careers differently than previous generations. Many are gravitating towards entrepreneurship or portfolio careers with multiple income streams rather than traditional employment. These generational preferences aren't merely personal choices, but reflect broader economic and social changes. Millennials entered the workforce during significant economic disruption. The Great Recession undermined the promise of stable corporate careers, just as many were graduating from college. This timing created lasting skepticism about traditional employment paths. Student loan debt has also pushed many towards side hustles and entrepreneurial ventures to supplement income from traditional jobs. Technology has dramatically lowered barriers to entry for certain types of businesses. Social media marketing, e-commerce platforms, and digital productivity tools allow individuals to launch businesses with minimal capital. This has fostered a sort of DIY entrepreneurship culture where starting multiple ventures is normalized. According to Deloitte's 2023 Global Millennial Survey, 58% of millennials aspire to start their own business, and 70% consider themselves working in some entrepreneurial capacity, even with traditional jobs. Remember our hypothetical at the beginning of this lecture about the babysitter? Now that you have more information about the gig economy, I'll ask the question again. Should the company that runs babysittermatch.com face any liability for Anna's negligence? Here's some of the key takeaways from this chapter. Work is changing. Technology and values are shifting the employment landscape. The gig economy blends freedom with instability, raising legal and ethical challenges. Worker classification impacts benefits, rights, and pay. Internships must provide educational, not just economic value. And younger generations seek autonomy, flexibility, and purpose. Some final thoughts on this chapter. As future business leaders, will you prioritize profits or design systems that respect and protect workers? The future of work is in your hands.